Desiree here. So it's come to my attention over the years, and all my years of being a paralegal and working in the criminal justice system, that people just really don't understand the criminal justice process. And with America being the number one country to arrest people and keep them locked up, it's important for us to know. So when you get arrested, the first thing that's going to happen is called a first appearance. You have about 72 hours to go in front of a judge, and it's a formal reading of the charges to you. This is not where you say, I'm guilty, I'm not guilty. They don't present any evidence. They're just reading the charges that you were arrested for. They want everybody to know, hey, this is what you were arrested for. Then, if you have a felony charge, what happens, and more specifically in the state of Georgia, this is kind of just the general process for the state of Georgia, but it could be different for other states. But in Georgia, the next thing that will happen is you'll have a preliminary hearing. And during this preliminary hearing for felony charges, this is kind of just where both sides are able to present evidence, and typically a magistrate judge will determine whether or not you meet the criteria, the burden of proof that you could have committed the crime. This is not a hearing where you determine innocence or guilt. This is a hearing to say, is there enough evidence to say maybe you could have done it? And if there is anything at all that a reasonable person could assume that you could have committed the crime, then the magistrate judge will bind it over to a higher court, typically a superior court, state court. If the charge is not bound over, then it's usually dismissed at that point. So let's say it does get bound over, and you will go to a bond hearing, because typically with misdemeanor charges, your charge has an automatic bond on it. But with a felony charge, it's case specific. So you're going to have to go and sit in front of a judge, and that judge will determine whether or not you get a bond and how much that bond will be. After you go to your bond hearing, then you will go to what we call the case will go to what we call a grand jury hearing. The grand jury is 23 people. It's not 12 people like most people assume. It's 23 people, and you have some alternates, and this you're not allowed to go to. Your attorney is not allowed to go in there. This is specifically for the prosecutor to go in and present all the evidence they have against you. And typically before they go in, what they'll do is they'll read through the Georgia Code, and they will find every single charge and every lesser charge that you could possibly be convicted of. And this is what we call charge stacking. They're going to stack as many charges as they possibly can in front of this grand jury. And the grand jury will deliberate whether or not you could have committed any of these crimes, right? So the burden of proof is not beyond a reasonable doubt at this point. It's just a reasonable suspicion, okay? So maybe you could have done it. So if I was at a party with like 50 people, and all 50 of these people say, yes, she was there at this party at this specific date and this specific time, but I have one person over here saying, no, she was over here and committed this crime, that's enough reasonable suspicion for the grand jury to indict you. Indicting means that they have said, okay, there's enough evidence to move forward with this particular charge. So the prosecutor presents all his evidence. He questions witnesses in front of this grand jury, and then the grand jury is going to either come back with a true bill or a no bill for each charge that the attorney presented to them. So if it's a true bill, that becomes an indictment, and if it's a no bill, that charge is dismissed. All right. The goal for the prosecutor here is to get something to stick, right? And then you move forward. After the indictment happens and you are indicted, then you're going to go to what we call an arraignment. The arraignment is just like that first appearance. The judge now has to read you the charges against you that came out of the grand jury, And this is going to be a formal reading of the accusations against you. This is the point where you can now say, all right, I'm guilty or I'm not guilty of these particular charges. Then, if you've said I'm not guilty, you're going to go forward to what they call a calendar call. And most calendars are about 6 to 8 weeks long. And they will call maybe 100 cases, maybe 200 cases. And they'll say, are you ready? The judge will ask both sides, are you ready? Your attorney and the state's attorney, they're going to say, are you ready? And if they both say that they're ready, then they will be put on that calendar for the next 6 to 8 weeks. Now, this is why the criminal justice system moves so slowly, because let's say I announce ready, the state announces ready, and we say it's going to take about a week to do the trial. All right? So they're going to try to find a week on that 6-week calendar for our 1-week trial. But remember, there were about 200 people that were called on this calendar. So if 20 people say that they're ready, then that's 20 weeks worth of trials. We can't fit 20 weeks worth of trials in a 6-week calendar. So they're going to call the oldest cases and the most high priority cases first. Those are going to go in front of the judge, and they're going to get their day in court. Some trials may take 1 day, some may take 2, some may take a week, some may take a week and a half, some take 3 weeks. It just depends. So they're going to try to fit as many cases on this calendar as humanly possible. And then if your case is not gotten to at that point, then it will roll over to the next calendar. So you have now waited 8 more weeks to get onto the next calendar. So now we're at a month and a half. And then you go to the next calendar and you say, yes, we're still ready. And then they try to fit you on there. If you're not ready, they'll just move you to the next calendar and the next calendar and the next calendar. And I call them dummy runs because most of the time you're not going to be seen for like 6 months to a year. So that's just the criminal justice process. And then the state will offer you a deal. They've been waiting, you've been waiting. Most people are ready to just get it over with. And so they're going to plead guilty and they're just going to take the charge, whatever lesser charge that the state offers them the deal for. And they're going to take their probation or their time and just get it over with. It takes patience. It takes courage. It's a daunting process. And most people lose hope and faith during this process. You just got to stay strong through it. But this is our criminal justice system. So it's good to be aware of what the process is so that you don't make any decisions that could possibly affect you for the rest of your life.